Hi, everyone.
Hi, Ravella.
Arabella.
Guys, I think I'm having some issues with my camera. Can you see me at all? No,
No, no.
bugger. All
You
right.
look like a ghost.
Yeah. Oh, here we go.
That's better.
There we go. Cool. All right. Well, I hope everyone had a nice festive season and a happy new year to everyone. I'm not sure how many students will jump on to this tutorial. So we might just give it a minute or two. But I also just wanted to say to our Southeast Corner constituent, I hope everyone's safe and the storms haven't been too disruptive. My heart goes out to you. It's been a bit of a crazy month for Queensland weather. Um, all right, well, we don't have too many more people jumping on, so we might get started. Before we jump into our week 7 material being death, burial, and cremation, just a quick update in relation to the first assessment piece. So my plan at this stage, so we're still marking. My plan at this stage is to release the grades on Tuesday. This is because I do have some students that have longer extension requests that are all falling due on the Monday, fingers crossed. So I hope that everyone can see the reason why I'm just waiting an extra couple of days so that we can release all the grades at once. I'll put a note up in the forum as well so everyone has this information, but just Tuesday is my plan. If there's any changes to that, I will let you know, but that's what we're working towards. I'll go through some general feedback on the assignment in next week's tutorial because there are some general themes that I can comment on. And given that we've got 100 people in this class, I want to make sure that everyone is getting sort of the same feedback where necessary. So that will be provided, but just once we've released all of the grades. Other than that, before we jump into the question, does anyone have any questions about the assignment or any of the material from this week? Nope. It's an interesting week, week 7. The death, burial, and cremation, it's not something that comes across your desk regularly in practice, but when it does, it's usually quite complex and intricate and quite interesting. So the scenario that we've got today, let's read through this one. So, and I should say this is, again, an opportunity to practice what we'll be doing in our second big assessment piece, the written assessment. So Wayne comes to see you in relation to his brother Darren's estate. Darren has passed away in his home and the cause of death is unknown. Wayne tells you that he believes it is because of a brain aneurysm and that Darren was discovered by a colleague who came looking for him after Darren hadn't attended work for several days. Wayne wants to start administering Darren's estate and getting things sorted out. He advises you that him and Wayne have 5 siblings. Darren was one of 7. But that one of their siblings, Peter, he doesn't know where he is. So we've got a missing sibling. You're advised that Peter attended Wayne and Darren's father's funeral approximately 10 years ago and that he hasn't been seen since. Wayne advises you further that Peter had always been the black sheep of the family, and it was not uncommon for Peter to go several years without contacting family members. However, when Wayne tried to contact Peter when their mother died 8 years ago, none of the siblings could locate him. So we've got mum and dad both deceased. Wayne instructs that they wrote to Peter's last known address and also called previous places of employment that they were aware of. They also checked the white pages, but none of these searches could locate Peter. In addition to the above, Wayne tells you that Darren had mentioned to him on several occasions that he never understood why people would be cremated. What if they were still alive? He tells you that one of his sisters, Leanne, thinks that Darren should be cremated, as this is the easiest option to organise. So, where do we start? We've got a few issues in this scenario. So our client
Well, let's
is
start by
Wayne.
verifying that Darren is dead.
Yes, absolutely. And how are we going to do that?
To get a certificate from the registrar, but wouldn't the first thing to do is to find out whether he had a will
Yes.
and to make sure that he hasn't died intestate?
Yes, absolutely. So both the will and the death certificate are absolutely essential because they're largely going to guide what happens with this estate. So with respect to the death certificate, starting with that, Luke, we're told though that the cause of death is unknown. So what do you think is going to happen in that case if we don't know cause of death?
Apply for a post-mortem examination that may be required to.
Isn't it in section 45?
So section 45 is the definition of death. But in this case, we don't actually know what the cause of death is. We're told that we think it's a brain aneurysm, but we're not sure. So at this stage, there's a possibility that the final death certificate can't be issued and that an interim death certificate may be issued if coroners need to ascertain cause of death. So what we might end up with is that interim death certificate that doesn't list a cause of death. So either way, we will need to end up.
Sorry, Arabella, you just,
Yeah.
your voice went all funny then. You said they would issue an interim death certificate if, and then it all went.
Oh, sorry. So if we don't know what the cause of death is, or if the coroner needs to make some inquiries and ascertain cause of death, we might just be issued with an interim death certificate. Once we've got cause of death, the final death certificate will issue. I think that's everything that I said. Now, with respect to the will, why is this so important? So we want to avoid intestacy and understand how the estate is divided. But what about Wayne?
Well, he wants to start administering Darren's estate. So
Grant of probate.
if there is a will, yeah, we need to know who is nominated as executor.
Yes. So if there is a will, what we need to be advising Wayne is there's a possibility that Wayne isn't named as the executor, and he may not be the appropriate person to be providing instructions regarding the estate administration. Cool. All right. Where do we go to next? Let's say there's not a will. Let's say we've looked for a will in the usual places, can't find anything, and we have to assume that Darren has died intestate.
Get one of the parties who has standing for an application for administration.
Yep. So let's say that's our guy Wayne. Siblings are happy for Wayne to act. I think the big question is going to be, as it always is, who's benefiting? Who are our beneficiaries going to be in this estate? What do we know from our facts?
All the siblings.
Yep. And that's because
the parents have passed away and there aren't any partners, spouses, or children.
Excellent. So what we'll also need to ensure is that if both parents have passed away, that when we make our application, that we've also got proof of their deaths. So in the same way that we'd need to make sure we have a death certificate for Darren, we'll need to make sure that we've got proof of death of mum and dad. All right, so the siblings are going to be our beneficiaries, but we're also told, I think Peter can't be located.
That would be a Benjamin order.
Potentially. So do you want to explain that? Was it Luke? Do you want to talk us through why you've suggested a Benjamin order?
That would be because Peter can't be found, but if he is found later, he can be entitled to the estate still.
Mm-hmm. Yep. Okay. So what if it's a little bit more sinister? What other options does Wayne have if he's our administrator in the context of death and this week's readings?
He could try to apply for an application to rebut the presumption of continuance of life, because it's been 7 years since any contact. But I felt that would be difficult given the fact that Peter does have a history of just like being unreachable, and a court may not like. You can't just say, I haven't heard from them from 7 years and the court just rules that they're dead. Like that, you still have to give the court, adequate sort of, an adequate example that there is a presumption that he is dead. And I think that would be difficult given that, in the past they've gone, years without hearing from Peter.
Yep. No, that's great. So what sort of evidence or what sort of searches do you think we could undertake?
Don't you advertise in those state newspapers?
Yep.
The website, I think, is the Supreme Court, Federal Court website also. I think there's a section there where you can public notices.
Yep, so we can advertise that we intend to distribute, and we're looking for Peter. What else might we do? Or do we not know? What do we think? Would we perhaps reach out to all of the siblings, see what contact they've had? We can contact family friends. We can contact places of employment, workplaces. We can really reach out to anyone that may have had any form of contact. We can search funeral notices. We can search our Supreme Court e-courts to see if he's died or if he's been involved in any litigation, potentially. So we can undertake a number of searches that will either assist us with an application or make it very clear that we should not be making an application. Is there anything else open potentially for us to do in this scenario? Would it be different if, for example, Peter, let's say previously had close relationships with the family, and let's say maybe you wouldn't hear from him every year, but maybe every year or two he got in touch. Yep. So then the last contact with Peter was 10 years ago, and then he couldn't be contacted 8 years ago, which would be quite unusual if Peter had previously been in contact with the family, had a close relationship. So it really does depend on your circumstances. But as I said, there are a number of searches that you can undertake that will guide you through this process. Any other?
Sorry, would
Yep.
If someone somewhere had made a missing persons report, would that go towards helping displacing that presumption of continuance of life?
Look, it would absolutely assist because you need to be able to provide sufficient evidence. So if that's the case, that a missing persons report or has been filed with police, searches have been undertaken to no avail, that would absolutely be very useful evidence for sure. Yep.
Arabella,
Yes.
just out of interest, have you ever been in this position in your profession?
I haven't been in the position where I've made an application with respect to the continuance of life, but I have been in the position where we've made an application for a Benjamin order. So we've been in a very similar situation to this where there just was no evidence, or there certainly wasn't, pardon me, sufficient evidence to bring an application to the court. So we just applied for a Benjamin order and were successful in that respect, because it really does depend on your evidence and what you can show the court, because it's not done lightly. And I guess the other thing to remember too is an application, if your application is successful, the court isn't saying, oh, this person is dead. So it's not really making a ruling or a determination as to whether or not the person is dead. That's a different type of application. So there's two different types of application. Pardon me. If you need a death certificate and the person most likely is deceased, that's where you apply to the court for a declaration. Sorry, I've just completely lost my notes here. Yep, an application to swear death, and that is where a death certificate will be issued. And that's usually in the case of, a plane crash or a common disaster where there's very strong evidence that the person is dead, but we just don't have proof of that. So we need to make the application for leave to swear to the death. If you do that, that means that a death certificate can then be issued, and then that can be provided, which is particularly useful in cases of joint ownership, or potentially too if there's life insurance policies or insurance policies attached to your superannuation that require a cause of death as well, potentially. So it really just depends on your situation and what you actually need to establish in order to successfully administer the estate and distribute to the beneficiaries. So here, going back to Darren's estate, we've got our siblings. We know mum and dad are deceased. We've got our siblings that are going to inherit. We need to ascertain what's happened to Peter in order to successfully distribute Darren's estate, and for Wayne, if he's the administrator, to complete his duties as the administrator of that estate. And I guess from there, if Wayne is administering Darren's estate, he may also consider whether or not it's then appropriate to deal with Peter's estate, because if Peter's estate does receive an interest, how is that going to be dealt with as well? So there's a number of flow-on effects in this scenario.
Arabella,
yes.
Just to ask, if you did all those things, like you mentioned, you went and ran the ad in the paper, you did all the searches and everything like that, you'd obviously put all that in your application to the court to say, we've done all of these things and nothing has come of it. Is it likely that that would be sufficient, that they would then issue an application for you to continue with probate?
So what you would do, you'd undertake all of your searches, and all of that would go into your supporting affidavit material. And in your submissions, you'd be relying on this evidence to make your submission that you know, for X, Y, and Z reasons, you know, the presumption of the continuance of life should be displaced. If that's the case, you will also be seeking in your application that a grant of probate be issued, or sorry, letters of administration, whatever the case may be issued to the applicant if the court is satisfied, you know, with your submissions, and then that application is successful. So you would absolutely put in all of the results of your searches, and it may not be just you as the applicant that files an affidavit. You may actually rely on other affidavit evidence from, you know, perhaps the last person that spoke to the deceased person or an employer. So you can collate everything that you will need, because, as I said, you want to make sure that you are putting as much evidence forward to support your position and to support your application as possible. Yeah. Talitha?
I just also wanted to confirm, so with a Benjamin order, like, as you said before, like if the person is alive and then they come forward subsequently, the people who've benefited have to relinquish. So if there was a situation, say in our scenario, if Peter had children who also hadn't seen, you know, hadn't heard from him for 10 years or whatever, they would be entitled to receive his share if it was determined that he had you know, if the court ruled that for the purposes of the estate, he predeceased Darren. So they would have to give, like, if he then came forward a year later and said, I'm actually alive, like, his kids essentially have to like give up what they've received, or alternatively, like the other 4 siblings would have to give back what they had received. Is that how it works?
Yes, but so correct. If Peter is deceased and he has children, his children are the appropriate beneficiaries, absolutely. With a Benjamin order specifically, it would be arguably very difficult. So from a practical perspective, for a person that's missing, if they were to come back and seek to enforce their legal right to this share of the estate, practically it would be very difficult because by making the Benjamin order, by making the application for a Benjamin order, the executor or the legal personal representative is protected, so no action can be brought against them for distributing in the specific manner. Secondly, the beneficiaries that have received this interest, it's in full and final satisfaction of any claim that they've had, so they are absolutely entitled to that interest. So if they've gone on, used those funds, purchase property, for example, it would be extremely difficult to enforce the return of any provision in circumstances where it simply no longer exists. So this is also why these orders are not made lightly by the court. So they really have to be satisfied. Also, with respect to the evidence that you're gathering, that you really have left no stone unturned, because they want to avoid the potential complications that could arise if appropriate searches haven't been done when the application is made. So technically, sure, they can come back, but practically we want to avoid it, and it would be very difficult for that person, the missing person, to enforce any right that they have. Yeah. I'm sure it's happened. I'm not aware of, just trying to think just in my sort of circle of colleagues, I don't think anyone's had that. I know cases are jumping to mind, but I'm sure it has happened. So there may be some case references out there. I'll have a bit of a think, but it would be very very unusual for it to happen. Yeah. Any other thoughts on missing Peter? Lost Peter? No?
So then if he did have a will, obviously it would just be that it goes by whoever the executor is, and Darren couldn't do anything. Oh, sorry, Wayne couldn't do anything to get, if he wasn't the nominated person. And
Yeah. So so Wayne's coming to see us, arguably in the capacity of the person that's going to be making the application. So he wants to get it sorted. He wants to start the administration process. So arguably he's the one that's saying, I want to action this. I'm the client. I'm going to be the legal personal representative of this estate. If there is a will though, Emma, absolutely. He may have absolutely no standing, unless, for example, and again, it would depend on the terms of the will, if Peter has perhaps been named as the executor, then it just starts getting complicated and messy. But yeah, that's why we need to know if there's a will, because we don't want to be giving all this advice to Wayne if he's not our client and he doesn't actually have standing to bring the application that he may need to bring.
And then the bit about the cremation, obviously, that's another part, because it's like, well,
Yes.
that's not in the will.
That's right.
They
Yes.
can't just cremate him, because it has to be, they have to double check that was his choice.
Yep. Yep. So that's right.
It would appear like he didn't make that choice, though.
Sorry, Luke, I cut you off. What was that?
I was going to say it would appear that he didn't make the choice to be cremated.
Yep, that's right. So Wayne tells you that Darren's mentioned to him on several occasions, presumably before he went missing, that he never understood why people would be cremated. So you can probably infer from that a desire not to be cremated.
Yeah, you could. It's a little bit ambiguous, isn't it?
Mm-hmm. So if that's the case, which legislation are we going to look at to help us?
Cremations Act 2003.
Perfect. And what specific provisions are we looking at in this case? So what if we did have instructions?
Is it section 7?
Yep, that's right. So if an or if a legal personal representative is aware of a person's instructions that they wish to be cremated, and these instructions should be in writing, these instructions should be followed. So that's in relation to being cremated and also not being cremated. So if someone...
What if it wasn't in writing? What if it wasn't in writing, though, and it just was said? That's not enough, is it?
No. And this is where arguments can really, yeah, reach a very nasty point. And I guess if you look then to section 8, if there's an objection to cremation by a spouse, child, parent, or legal personal representative, then the cremation can't proceed. So arguably, I think it's Leanne, you know, do Leanne's comments amount to so Leanne, sorry, wants Darren to be cremated, and Wayne doesn't want Darren to be cremated.
So does that come down to which one of them is the executor?
Yes, ultimately. Yep. And if there was anything in writing regarding Darren's preferences around cremation. Sorry, I'm getting my names mixed up today. I think my brain's still in holiday mode.
So if Leanne wanted it and Darren's the executor and Darren didn't want it, Darren can make the final decision subject to section 8 if there's an objection, that he can decide we just go with burial because we don't have enough information.
If it's
right?
So if Wayne makes the decision to bury, then that will proceed. Specifically with cremation, if it was switched around and Wayne wanted to cremate Darren and Leanne had an objection to that, that objection would need to be dealt with before any action could be taken. But if Wayne is simply saying, no, we're not cremating, I want to bury, Wayne, as the legal personal representative, has the authority to deal with Darren's body, and he is responsible for organising the funeral and determining burial or cremation in this case. Yeah.
I think the textbook also says, quote, at common law, they were not obliged to follow any direction given to them by the deceased for burial or cremation.
Mm-hmm.
So basically the administrator has the power and is not bound.
Yeah. So the legal personal representative does have, I guess, the authority. But if, as I said, if there are instructions in writing that the deceased person wishes to be cremated, they should, where possible, be followed. And this, again, if there's express instructions and they are not followed and there's not a good enough reason, again, this is where tensions and conflicts can arise, particularly if there are cultural reasons attached to a decision made by the deceased person. So, for example, some cultures do not believe in cremation at all. Some do. Some cultures obviously have, I guess, specific processes that should be followed with respect to burial or death. So again, where possible, these should be respected. And if they're not respected, there does generally need to be some good reasons why, because again, it can give rise to a lot of tension and conflict, which then costs a lot of money and takes a lot of time to resolve. So this is why too, a lot of solicitors, when they're drafting wills, will include specific funeral directions and directions as to whether or not the deceased person or the will maker wishes to be buried or cremated, how, whether or not estate funds can be used to fund certain activities, so a wake or a celebration, just to avoid the dispute and to provide as much direction to their executor as possible. Great.
If a person, if the deceased person is cremated, who would it be? The personal representative who gets to decide what to do with the ashes?
Yes. And what I will say is the holding and the dispersing of ashes is something that you can spend tens of thousands of dollars on arguing, and I've got a number of these matters sitting on my desk right now. So again, very, very contentious area, cremation and ashes. Yes, speaking from experience, it's not fun to deal with. I think, look, just anecdotally, I think people, and you've potentially have experienced this yourselves, the ashes symbolize the deceased person. So people feel very strongly about what should and shouldn't happen to the ashes. But at the end of the day, it's the legal personal representative's duty and responsibility to determine what happens with the ashes. So just something to keep in the back of your mind. Also, the other thing just to remember is that any costs, and this is what I touched on just briefly, the costs of the funeral and the cremation, they're considered a testamentary expense, so they can be borne from the estate, provided they're reasonable. Again, this is why, pardon me, if a will maker wants a very specific after death celebration, for example, it's really key that you draft your will on terms that reflect that and authorise the legal personal representative to use estate funds to meet these wishes. In Queensland, if you find yourself in the situation where the estate is insolvent potentially, funeral expenses will be paid above any other debts. And quite often too, well, not quite often, but in some cases, banks will actually release funds held in the deceased person's bank account to meet the costs of funeral expenses without the need to provide a grant of probate, for example. Just depends on the bank and I think perhaps their requirements and potentially the cost of the funeral, but funeral expenses seem to be the item that banks will release funds before anything else. So something to keep in mind.
And that's in the absence of getting a grant of probate, you said?
In the absence or before you've had the opportunity to actually obtain the grant. So obtaining a grant, as we'll sort of get to in the next few weeks, can take about 3 months roughly. And quite often people just want the funeral paid for, finalised and dealt with. So usually either on the production of perhaps the will and the death certificate or even an interim death certificate, the bank will release funds purely to cover the funeral expenses. So later on down the track, so let's say there's $50,000 sitting in the person's bank account, the funeral's $10,000, the bank might release the $10,000 and then later request and wait for a copy of the grant before releasing balance funds. Cool. Any other questions or comments around our scenario with Wayne and Darren regarding his funeral?
I think at the beginning we forgot to mention that there's an obligation to dispose of the remains of the deceased.
Yes. Yep, which falls to the legal personal representative. Yep. Yep, absolutely. So Wayne needs to be taking those steps. Any other questions? Just checking back through the scenario and any question or points that I've jotted down. I guess it's worth mentioning too, not relevant to this scenario, but just to make sure that people are across this concept, is Section 65 of the Succession Act, just in relation to the presumption of survivorship, where you've got 2 or more people that have died in a common accident. So just for those, if you haven't had the opportunity to read it, Section 65 says, subject to the Act, where 2 or more persons have died in circumstances rendering it uncertain which of them survived the other or others, such deaths shall, for all purposes affecting the title to property, be presumed to have occurred in order of seniority, and accordingly the younger shall be deemed to have survived the elder for a period of 1 day. So in a nutshell, if you've got 2 people, let's say a father and a daughter, father's 50, daughter's 35, the law presumes, if we don't know who died first, that dad, being the oldest, died first, and then the daughter, being the youngest, survived him for a period of 1 day. So this is just something to make sure you're across. The other thing to note, just in the context of the 7-year rule that we've discussed and decided that may not be appropriate in our scenario, is that if the death is presumed, Section 65 won't have any application. And this is because there's no presumption made as to the time or date of the death. So again, just something to make sure you're comfortable with. And obviously our two sections 33B and 35(2), regarding the requirement that a beneficiary must survive by 30 days in order to receive an interest from the estate or to take on intestacy. So just flagging those to be across, they're pretty key sections in this context. Beauty. Questions? I know there's not a lot of content in this week, but it's quite interesting, I think. I think there's a few cases in the recommended readings or the optional readings that might help. I have got quite a good paper, I think, around traumatic deaths. So I might have a look through that and see if there are some cases that I can pop up that might be of interest just in this context. But as I said, it's quite rare that you'll have many of these on your desk. And Benjamin orders can sometimes be a little bit easier, particularly if you don't have too much information or you can't really get to the bottom of what's happened one way or another.
So, in a nutshell, in relation to the 7-year rule, so with regards to Peter, the court will presume death if Wayne and everyone else have exhausted all avenues, left no stone unturned to find. So the court will presume after 7 years that he's died, but it's not set in stone, and it does not raise any presumption of fact. So if Peter happens to surface after 7 years, then he can then make a claim on this. Well, yeah, make a claim.
Potentially. But again, practically, if the estate has been distributed, there's probably no estate left for him to claim against. So the right of action is there, but it's unlikely that he's going to have a particularly good outcome, I would suggest. Yeah. Cool. Any other questions, comments, thoughts?
It was interesting reading some of the cases just about like when you buy your burial site, like if you can't, how people sometimes argue because they've bought a particular site or block of dirt and that was next to someone else's grave that might have been a family member, but something's happened and they can't get it. There was some interesting reading about that, which I thought was interesting.
Yeah, that does come up.
Yeah.
I have dealt with the issue of the burial plot once or twice, and it can be really difficult because it's a proprietary interest ultimately in this plot, and yeah, it's very bizarre. I learned a lot when I had to go through the process of it was in the context of administering an estate where one of the assets was this right to an internment and this plot, and sort of what to do with it and finding out who really owned it because it had been in the family for a very, very, very long time. And I think the deceased person had purchased it, perhaps when they got married in their 20s, and they died, I don't know, 50 years later. So yeah, it is quite interesting. I think in the end, I'm trying to think. I think that the beneficiaries agreed and instructed the executor ultimately to sort of relinquish or to allow some sort of buyback of this plot. Yeah, I think it,
Once someone's buried, you can't even dig them up or whatever.
no,
And like I know just from my own experience when I had to bury my brother and my dad, and when I went there, my dad had bought this block of where he wanted to go, only not that long before. But the funeral guy at the cemetery that ran the cemetery, he'd said, oh, you know, you're a mate because they grew up in a country town and all this, you know, $50 and, you know, you've got that particular plot, you know.
yeah.
And so it was interesting just when you go out there and you look, because there's actually little picks in the ground which actually have different people, you know, and you have to be so far apart and all this. And yeah, and I was surprised too, like even with cemeteries, how they sometimes have spots where younger babies are buried versus other. That was quite interesting, where children have died at very young ages. They actually have a certain section in the cemetery. I've actually seen that in a couple of cemeteries. So, you know, if you wanted to bury them next to a family member, there's a lot of different rules. So it's a bit of an interesting story.
Yeah, and I think that's an interesting point. Emma. The cemeteries themselves may have rules that potentially could conflict with the deceased person's wishes and what the LPR wants to do. Yeah, no, it's very interesting, all of this.
It's very political.
It is very political, very political. Yes.
Hopefully we'll never get one of them come over our desk. We'll go, we'll bring Arabella.
Oh, look, it's I think whenever you're faced with something like this, just get as much information as possible. That's always my starting point. And look at your legislation and go from there. And I anticipate that if you are dealing with not a nursery, a funeral home, getting on the phone and just finding out as much as you can about how they work, rules, requirements, sort of any restrictions that you have, that will hopefully lead you down the right path, so that you can advise your client and you can reach the outcome that you need. But look, the Benjamin orders, and I guess too, you know, the 7-year rule, they are very, very interesting, and they can be very useful applications if you do have the evidence, and you can, you know, get all your ducks in a row. So I'm very confident that if something did come across your desk like this, with enough sort of investigative work, you could, you know, decide one way or another which way to go. For sure. You can always call me.
Mentioned before, yeah, you know, when you mentioned before about e-court, like looking to see if the person's had any litigation, can you just explain that a little bit better? So what site's that you go on to?
Yeah, sorry. So if you go onto the or just Google, you know, Supreme Court of Queensland, I'll just quickly do it now and I can show you. Basically, you can search your Supreme and District Court matters. If you know, the applicant or the plaintiff.
Generally, people who go missing in action can generally be homeless type people, or they can be people who live on the streets with schizophrenia or alcoholics, and they live in homeless shelters, and they could be your long lost uncle who you haven't seen for ages, and generally likely to be involved with the courts for drug matters or something.
Yeah, absolutely. So I'm hoping that I'm sharing. Oh, no, I'm not yet, am I? Here we go. I think I'm sharing. So basically, if you go to your Queensland Courts page, just courts.qld.gov.au or Google, and then you can scroll down to this section which says search civil files. If you click on that, party search, e-courts, click on that. So you're basically brought to this page here, and it's just a number of drop downs and different sections. So I'm just trying to think, maybe by admission. So if you've got the party details, for example, hope this works. Yeah, cool. So here, because I search my name as an applicant, you can see the different types of applications or matters that have arisen. So this was my admission. I'm trying to remember what this is, which isn't ideal. Oh, so this is an old one. So here, this was an application for probate. That's right. I think we may have been acting in the capacity or as an attorney potentially in this matter. And I can see that it's been requisitioned. So we'll come to this, but a requisition basically means that the registrar isn't happy with the information that you've given them and they want more information. But as you can see all the parties listed, all of the documents that have been filed.
So that would tell you what year roughly that person was associated, what
yeah.
Okay.
Yeah. So there's quite a bit of information that you could potentially get from a court search.
Can you make an application to Medicare or Centrelink, or is there a way of doing that as well if you needed to find something out? Because I know in some other instances you can make an application, like if it's for, I remember with one of the others, I think it was civil procedure or something, we were able to make an application if we needed someone's details.
Yeah, look, potentially, and you can, yeah, if you can. Sometimes Centrelink in Medicare, I think you said, sometimes you need to be, you can request very specific information, and quite often with those sorts of searches, you yourself need to have very specific information to provide before a request for information or confirmation of information will be provided. But yeah, that is absolutely another potential avenue that you'd go down. Yep, for sure. No, that's okay. I'll put the maybe just out of interest for people, I will put the eCourts or the courts link in the forum. So if people want to have a bit of a look, have a little bit of a play around, that's there. It's also really useful, I guess, if you do go into practice, or as we'll come to a little bit later on, if you don't know if a grant of probate or letters of administration have been applied for, or if a caveat has been filed, you can search this information on eCourts. Similarly, in Victoria, there's a similar searching function, and most jurisdictions do have, eCourts in some form or another. So very useful tool in practice, really. All right. Any other questions? We're at 6:53, so we're nearing the end of our time, but we do have a little bit more time for questions if people have them, or we might be happy to wrap up there for this week.
Sounds good. Thank you.
All right, everyone. Well, thank you for your attendance today. If you do have any other questions that you think of after, feel free to get in touch with me, and I'll see you all next week. Thank
Thanks,
you.
Sarah.
See you later.
Next week.